Well, I should begin by saying that I shall be having some very serious words with Alison on the train back to London later this afternoon, because I'm afraid she seems to quite deliberately have gone out of her way to show me up today. She has placed before you a whole series of clear and helpful slides, and I'm afraid that I have prepared precisely one slide, which contains the title of my presentation, Corporate Failure to Prevent the Facilitation of Tax Evasion, the UK's Extra-Territorial Criminal Offences. A catchy title, I'm sure you'll agree, a bit of a mouthful, but it was my attempt to encapsulate in the title of my talk the essential subject matter which I'm going to try to cover. Specifically, it is to do with the so-called failure to prevent offences under a UK statute called the Criminal Finances Act 2017. And having said that, I suppose the very first issue that I need to address is probably, why is any of this of any conceivable relevance to any of you? Why should you pay a moment's notice to a piece of United Kingdom criminal legislation? Well, I think there are probably three reasons why it might be worth your spending a minute or so considering the new legislation which I'm going to be talking about today. The first of them, really, the clue is in my title. It is that the Criminal Finances Act 2017 has wide-ranging and pretty unprecedented extraterritorial effect. So it is more than capable of affecting a bank's operations wherever in the world they may be operating. The second reason, I think, is that this statute seems to me, at least, to be part of a long-term trend of ever-increasing regulation in the financial sector. It is a piece of legislation which imposes obligations on companies and partnerships in relation to the prevention of tax evasion by third parties. It is what I like to call one of the three terrible triplets. The other two, from the point of view of anybody working in this sector, the other two terrible triplets being AML, anti-money laundering, and the obligation to prevent laundering activity by third parties. And the second terrible triplet is anti-corruption and the obligation to prevent anti-corruption by third parties. Well, this is the third and most recently born terrible triplet, the obligation to prevent tax fraud by third parties. The third main reason why it's probably worth a second glance on your part, even though it's United Kingdom legislation, is that it seems to me, at least, that it is likely to herald similar legislation in other Western capitalist economies. Why do I say that? Well, not because I have some magical crystal ball which I can peer into and see the chancelleries of Europe and departments of state in the US or wherever it may be busily honing legislation of this sort. It's simply this: a lot of United Kingdom businesses often accuse the United Kingdom government of what is called gold plating. I'm sure you know what I mean by that. It is the idea that our government, in the United Kingdom in particular, seems to be in the habit of going much further than it is strictly required to in enacting into domestic legislation pretty onerous requirements on business which are intended to give effect to the United Kingdom government's obligations under international agreements. It often enacts in UK legislation requirements which go much further than, strictly speaking, would be required pursuant to the government's obligations under international agreements. And for that reason, it is likely, I think, that the legislation that I'm talking about this morning will be a trailblazer for similar legislation which may follow either here or in other European countries or elsewhere in the world. So those are some reasons why it may be worth at least a passing glance at this UK legislation. Now, the Criminal Finances Act 2017 came into force in early September 2017. It's worth, I think, before I get onto the provisions of the Act itself, probably just summarising briefly and looking at the political and the consultative background to the Act. The political background is really the very high-profile scandals which took place in relation to the tax affairs of the super rich and the part played in their tax affairs by various professionals, accountants, lawyers, professional trustees, banks. The sorts of scandals that came to light in the Panama Papers, Mossack Fonseca, in the HSBC Switzerland secret accounts case, and then more recently in the so-called Paradise Papers case. So that sort of background of scandal in relation to tax affairs and the part played in those tax affairs by various professionals. And then there's also, in terms of the political background, what I would characterise as the continuing sequelae from the worldwide financial crash. Now, they're still being worked through, certainly in the United Kingdom, I'm sure in other jurisdictions worldwide. We in the United Kingdom have gone through a period of what's called austerity, effectively the slashing of government spending on what would in more normal times be regarded as essential services. And that background has led to a deep and profound unpopularity for, frankly, the rich generally, and I have to say, bankers in particular. So that is the political background to this legislation. The consultative background, or what I mean by that, well effectively, what underpins this legislation is the United Kingdom government's strategy for tackling tax evasion. They published a paper called No Safe Havens, and the paper set out 5 general aims. Firstly, that there should be no jurisdictions where UK taxpayers feel safe to hide their income and assets from Her Majesty's Revenue and Customs. Secondly, that any would-be offshore evaders should feel that the balance of risk is against them. In other words, they'll think twice before they do it. Thirdly, that offshore evaders, tax evaders, should be induced voluntarily to divulge the true position and pay any tax due, and thereafter to remain compliant in their tax affairs. Fourthly, that any who don't come forward should be detected and face vigorously enforced sanctions. And fifthly, that there should be no place for facilitators of tax evasion. Now, the first 2 of those 5 key principles, no jurisdictions where taxpayers would feel safe in hiding their assets and feeling the balance of risk against them, those are really catered for by what is now the so-called Common Reporting Standard, which I'm sure you'll be familiar with. It is an unprecedented step change in the ability of tax authorities worldwide to tackle offshore tax evasion. And it involves a far-reaching, automatic and greatly increased exchange of taxpayer information at the international level. The third of the 5 principles that I've mentioned, inducing taxpayers voluntarily to come clean, it is really dealt with by various disclosure mechanisms which encourage taxpayers to make a clean breast of things and to be good boys from now on. And it's the fourth and fifth of the principles set out in No Safe Havens. Any who don't come forward being detected and facing vigorously enforced sanctions, and there being no place for facilitators of tax evasion. It's those fourth and fifth principles which are really aimed at by the provisions in the 2017 Act, what might be called the failure to prevent offences in the 2017 Act. Can I then come on to the provisions of the Act itself? It's worth starting with the long title of the statute. It is, according to its long title, an Act to, amongst other things, create corporate offences for cases where a person associated with a body corporate or a partnership facilitates the commission by another person of a tax evasion offence. The aim of the statute is pretty transparent. It is, in reality, to transfer an investigative and self-regulating role to the private sector on pain of criminal sanctions, with corporations and partnerships being at risk of criminal liability and criminal penalties, really swinging financial penalties if a corporation or a partnership is convicted of one of these offences. But it's transferring that investigative and self-regulating role to the private sector on pain of criminal sanctions, with corporations and partnerships being at risk of criminal liability and swinging criminal penalties if they fail to regulate and police themselves. That's the aim of the statute in reality. The scheme of the statute, the means by which it seeks to attain that aim, is essentially that where certain circumstances exist, and I'll come on to the conditions for criminal liability, where certain circumstances exist, it creates corporate criminal offences of strict liability, subject only to a statutory defence of having put in place so-called reasonable prevention procedures. But in relation to that statutory defence, the burden of proof is on the corporation or on the partnership. So it's strict liability with a reverse burden in relation to the only available statutory defence. Excuse me. And it's probably important to note at this stage that the particular circumstances in which that reverse burden is triggered differ slightly depending on whether one is concerned with the evasion of UK taxes or the evasion of the taxes of another jurisdiction. There's a dichotomy in the 2017 Act between effectively two offences or two sets of offences, one relating to the facilitation of the evasion of UK taxes and the other relating to the facilitation of the evasion of taxes in other jurisdictions. And I'll come on a little bit later to the precise differences between the two. Let me start with the offence in relation to the facilitation of UK taxes. I'll refer to the section, it's probably not of much interest to you. For what it's worth, it's section 45 of the 2017 Act. And section 45 creates, as I say, the corporate criminal offence of failure to prevent the facilitation of tax evasion in relation to United Kingdom taxes. It brings into play three key concepts because the offence is committed by a, quotes, relevant body where a, quotes, associated person commits a, quotes, tax facilitation offence. So three key concepts: relevant body, associated person, and tax facilitation offence. Let me just turn to each of those in turn. Relevant body. In other words, what manner of organisation is potentially capable of being caught by these criminal provisions? And the answer is virtually anywhere in the world. A relevant body which can be caught by these provisions is defined in the Act as being a body, corporate or partnership wherever incorporated or formed, and that means wherever in the world incorporated or formed. So there's one early indication of the sheer extra-territorial effect of these provisions. What about the second concept, an associated person? Well, slightly tautologous, not to say opaque provisions, but what it comes to is in effect this: an employee, an agent, or any other person performing services for or on behalf of the corporation or partnership. That's an associated person. So when one's looking to see whether an associated person associated with the corporation or partnership has facilitated tax evasion, that is the very wide definition of who is an associated person for these purposes. And then the third concept, tax facilitation offence. Well, this is probably the only piece of reasonably good news in these provisions. It's not all bad news, because the effect of the provisions is that before the corporation can begin to be at risk of criminal liability, at least 2 individuals have to be shown to have committed a criminal offence. There must be a taxpayer who can be shown to have committed a tax evasion offence. They don't need to have been convicted of the offence, but you need to prove, or the prosecution need to prove, that the taxpayer or a taxpayer has in fact committed a tax evasion offence. Now, the second individual who needs to be shown to have committed an offence is the associated person of the relevant body. And it's absolutely clear, it's crystal clear, that what the legislation has in mind is an individual within a corporation or partnership providing either financial or professional services to the taxpayer. Now, that individual, that person associated with the company or partnership providing financial or professional services must be shown on evidence to have engaged in conduct giving rise to what's called secondary criminal liability under United Kingdom law. And that means effectively aiding, abetting, assisting or procuring the commission of the primary tax evasion offence. So that's the definition of tax facilitation offence. I mean, I suspect the question most often asked when people look at these new provisions is, what does it actually mean? What does the taxpayer need to have done? What does the so-called facilitator need to have done? And for the purposes of today's talk, it's probably sufficient to refer to the government's own guidance on this legislation, which makes absolutely clear that the associated person, the so-called facilitator, must have acted deliberately and dishonestly to facilitate the third-party taxpayers' evasion. Unwitting facilitation of tax evasion through accident or through ignorance or through negligence is not capable of giving rise to one of the new corporate facilitation offences on the part of the corporation or partnership with which the facilitator is said to be associated. If those circumstances are made out, so if those 3 boxes are ticked, we're then in the territory of strict liability subject to the reverse burden of proof. The corporation or partnership will be in place reasonable prevention procedures to prevent persons associated with it facilitating tax evasion offences by third parties. Again, in relation to that part of the statutory scheme, guidance that has been issued by the government, actually pursuant to an obligation contained in the Act, section 47 of the Act, imposed a requirement on the Chancellor of the Exchequer to issue guidance for the use of the corporate sector as to what would amount to reasonable prevention procedures. And it is actually, for once, quite helpful guidance. The first set of guidance was issued on the 1st of September 2017, at the same time as the Act came into force. The offences, in fact, came into force at the end of that month, 30th of September 2017. I won't go into them in detail because they're quite thick and chunky, and we haven't got time today. I'll deal with it in two ways, if I may. The guidelines prescribe 6 guiding principles for compliance, namely the need for risk assessment, a requirement of proportionality, which means, according to the guidance, that the procedures put in place must be dependent on and reflect the risk assessment that's been carried out. There must be top-level commitments, so effectively board-level senior management needs to demonstrate a commitment to giving effect to these provisions. There needs to be due diligence. I don't think I need to say anything more about that. There needs to be communication, which includes training of the staff of the corporation and partnership, and there needs to be monitoring and review. Those are all familiar concepts for anybody who's ever concerned with corporate governance. The other way in which I'll deal with it, if I may, is to refer to the specific words of the guidance, where it says, ultimately, relevant bodies need to sit at the desk of their employees, agents, and those who provide services for them or on their behalf, and ask whether they have a motive, the opportunity, and the means to criminally facilitate tax evasion offences, and if so, how this risk might be managed. Just think about that for a minute. The guidance from the government says, effectively, you need to put yourself in the shoes of all of your employees at all of the desks in all of the offices that you've got, which I suspect for an organisation like this, or many similar organisations, with offices worldwide, no doubt thousands of staff, that is, if you'll forgive my language, a hell of an undertaking for the corporation to basically try to look at everything through the eyes of all of its employees at all of their desks. That's what the government guidance says is the essential approach that needs to be taken to reasonable prevention procedures. I ought to say something about the relationship between these provisions and parallel civil and regulatory regimes. And I say that really for a practical reason, because I suspect that the first port of call, or at least the first instinct of many corporations who are considering how to deal with potential liability or vulnerability under these provisions would be to say, well, actually, we've got all sorts of measures in place under anti-money laundering provisions and anti-corruption provisions. It's pretty clear from all the discussion there's been so far that it will not be regarded as sufficient simply to refer to your, or to adopt, or to regurgitate your AML procedures and your anti-corruption procedures. The key tool in reasonable prevention procedures is going to be the risk assessment, and all the discussion suggests that it's going to be a pretty tough combination of KYI, know your intermediary for bribery and corruption purposes, and KYC, know your customer for anti-money laundering purposes. They are new requirements, they are new obligations, they are going to sit alongside and complement AML and anti-corruption, but you're not simply going to be able to translate across to these new provisions work that's previously been done in relation to those other strands of regulation. Can I then come on to the question of who can commit these offences? And this is where it becomes pretty breathtaking. I think I've really touched on this slightly already, but the thing to have in mind is that the United Kingdom tax offence, so where it's the first link, where it's the facilitation of tax evasion in relation to UK taxes, that offence can be committed by any corporate or partnership, irrespective of where in the world that corporate is incorporated or based. It doesn't need to be a UK company, it doesn't need to have any UK presence. Neither does the associated person who is said to have facilitated the tax evasion by the third party. They don't need to have any link with the UK, to be based in the UK. They don't need to have been in the UK at the time that they facilitate the evasion of the UK tax offence. It's incredibly, breathtakingly wide-ranging, and the goal, the explicit goal, according to the United Kingdom government, is to enable the United Kingdom authorities to tackle facilitation of all UK tax evasion wherever in the world it occurs. Can I then come on to the second limb, the other half, if you like, of the dichotomy, which is section 46 of the 2017 Act, and that is failure to prevent an associated person's facilitation of a third party's evasion of foreign taxes. Essentially, it's the same approach as under section 45 in relation to the evasion of UK taxes, except in two important respects. There is a dual criminality requirement. I don't think I need to describe to you what that means. Effectively, there needs to be some relationship bearing between what is said, the nature of the taxes said to have been avoided in the foreign jurisdiction, and whether that would amount to tax evasion in the United Kingdom. So dual criminality. And there also needs to be a United Kingdom nexus. There does need to be a nexus with the United Kingdom in order for the section 46 offence to be made out. So, given its rather radical extra-territorial outlook, the foreign tax offence can only be committed by a corporate that does have some United Kingdom tax nexus for its business in the sense of either being incorporated in the United Kingdom or carrying on business or an undertaking in the United Kingdom, or the criminal facilitation by the associated person taking place partly within the United Kingdom. Those are pretty low hurdles to clear for the prosecution, if you think about it. If you have, there need be no other connection with the United Kingdom. Everything can have taken place elsewhere in the world. The taxes being evaded relate to an entirely different jurisdiction. The corporation can still be at risk under these provisions if it has one person based in the United Kingdom or an office in the United Kingdom. That is sufficient UK nexus. Equally, even if there's no base in the United Kingdom, but a part of the evasion facilitation takes place in the United Kingdom. So there's one meeting at one stage in the chronology. That is a sufficient nexus for the purpose of making out the section 46 offence. I think you'll begin to see why I began my talk by saying it's pretty unprecedented, the extra-territorial scope of these provisions. I'll just cut out a little. I'll come on to, because I've really used up my time, just a quick review of concerns about the future. Most of us, like myself and Allison and our colleagues at Red Lion Chambers, many of them, who do specialise in, as she said, fraud, corruption, money laundering, most of us believe that there will be a slew of prosecutions under the Criminal Finances Act 2017 and the failure to prevent provisions. We say that partly because of the bodies which are given jurisdiction to investigate and prosecute. The United Kingdom tax offences, part of it, will be investigated by HM Revenue and Customs, but prosecutions brought by the Crown Prosecution Service, which is our main public prosecution agency. The foreign tax offence provisions will be investigated either by the Serious Fraud Office or the National Crime Agency, and will be prosecuted either by the Serious Fraud Office or the Crown Prosecution Service. So a number of bodies are entitled to make use of these provisions, and frankly, bitter experience on the part of those of us who labour at the coalface day in, day out in front of juries in London and elsewhere in the United Kingdom. Bitter experience suggests that there will be a slew of prosecutions very soon, because organisations that are provided with these draconian powers tend to want to demonstrate to their political masters that they are making use of them, not least because they have an eye on next year's budget. And so we can be pretty sure that we will have a number of high-profile show trials pretty damn soon under these provisions. And really finish with this. I don't want to scare anybody unnecessarily, keep people awake at night, but many of us think that these new provisions are not necessarily going to be the end of the creeping regulation of the financial sector through criminal provisions. I've talked about the terrible triplets. We're expecting a fourth child pretty soon. We think that this is likely to be a precursor for another failure to prevent offence, this time in relation to economic crime generally. And just think about that for a moment and think how scary that's going to be, when corporations and partnerships worldwide are subject to an obligation to prevent the facilitation not just of tax offences, not just of money laundering, not just of corruption, but of economic crime generally. It's going to become seriously onerous at that stage. I've used my time. I did ask before Allison kicked off whether there would be scope for taking questions if anybody wanted to ask questions. I'm told that we're entitled to override if anybody does want to ask questions. We're very happy to. If not, we'll be entirely content.
Of course, there is time for questions. So
I don't know if anybody has any questions relating either to mine or to Alison's presentation.
I have one. I don't know if it is out of your scope or the topic. We have headlines in France regarding taxing GAFAM.
Taxing?
The GAFAs, the Google.
Yes, right.
So is there a possibility with this new text to find a way?
It'd be lovely if it was. I can't tell you the number of jury speeches I've done defending, particularly defending individuals, where I have bemoaned the fact that there seems to be a double standard on the part of the UK taxation authorities, prosecuting authorities. We call it plucking the low-hanging fruit. They're very happy to pick off the little guys who don't really have the wherewithal to defend themselves. They seem much more reluctant to take on the really big players, and indeed it's worse than that. We had a lot of publicity in the last 4 or 5 years about, frankly, unhealthy, I'm not being too controversial if I say that, but what look outwardly sometimes to be slightly unhealthy relationships between senior management at HM Revenue and Customs and senior management in some of the big internet companies, big telephone companies, and those sorts of worldwide global organisations. So it's certainly a big issue with the public in the UK, and if anything, I'm encouraged to hear it might be the same here, because who knows, maybe somebody will try to do something about it someday. And as I say, I speak as somebody, as Alison said, who works on both sides. I used to be standing counsel to Revenue and Customs, so effectively a chief prosecutor. The last 5 or 6 years I'll be doing much more defending, but I still work on both sides, and frankly I think it's embarrassing, the double standard that seems to be applied on some occasions. Any other?
Quick question from the back of the audience.
Yeah.
Listening to your explanation, it seems to me that the kind of come structures in Germany, the kind of capital gains structures that were used in Germany to reclaim kind of withholdings on dividends
Right.
that were processed innocently by banks
Yeah.
would fall squarely within this piece of statute. Is that the case?
No, the answer is not if they're processed innocently. Because the one saving grace of the legislation is that, and of the guidance, is that it is made very clear that the corporation's vicarious liability for the actions of its associated person can only kick in if there has been deliberate, dishonest misconduct, ignorance or negligence, or simply missing it, will not be sufficient. That is the one safeguard, if you like, that is at the centre of the legislation. So it does have to be deliberate, dishonest misconduct on the part of the individual. If that is demonstrated, then it's strict liability, effectively, for that individual's employer or corporation, unless they can demonstrate that that happened despite them having put in place reasonable preventative measures.
But any element of knowledge on the part of the agent processing the tax reclaim would inculpate the entity, the company.
If it's knowledge which necessarily connotes dishonesty, yes. Yes.
My question relates a bit to the previous one.
Okay.
How is tax evasion determined or defined? Because there can be a fine line between tax avoidance or tax evasion.
If I may say so, that is a very, very perceptive question. I'm not flattering you. It's a point I should have made. It is, I suppose, another of the saving graces of the legislation, that one of the hurdles which the prosecution authorities will have to clear when they are seeking to tick the box about there having been a tax facilitation offence, is they will have to demonstrate that it was evasion and not avoidance. I mean, the only thing I would say is that the line between avoidance and evasion in the United Kingdom is being steadily blurred in favour of the prosecution authorities. I spent 9 months last year at the Southwark Crown Court, which is our primary fraud court in London, defending a New Zealand-born but London-based solicitor who provided legal services to what would have to have been described as an aggressive tax avoidance scheme, but would at the time undoubtedly have been described as a tax avoidance scheme, and then the revenue moved the goalposts and chose to regard it as evasion, and there is a lot of that going on at the moment. The revenue is now characterising as evasion a lot of conduct which hitherto I think it would have accepted was avoidance, which it wanted to stamp out, but which did not lead to criminal liability. But you're right, you're absolutely right to raise the issue, because the prosecution authorities will have to demonstrate, when seeking to tick that box about tax facilitation offence, that it was evasion, not avoidance.
I have one quick